right? Okay, so at 7:03, let's get the meeting started. Paul, let us know when we're recording, or somebody let us know, whoever presses the button.
This meeting is being recorded.
There's that woman. Okay, at 7:03, I will call the meeting to order. It's a meeting of the Town of Norton Zoning Board of Appeals. October 7, we scheduled this meeting especially at our last meeting date in September at the behest of a couple of applicants, I guess, who wanted to be continuing with their applications sooner rather than later. We have 3 items on the agenda tonight. The first is a continuation of hearing started on September 16. I believe it was September 16. Correct me if I'm wrong. Is there a motion to take from the table for further consideration the continued hearing for 157 Mansfield Ave, Norton Mobile Home Park, which was continued from September 16 on an appeal of the building inspector's decision?
I will make that motion.
I'll second it.
Okay, thank you. All those in favor? Sorry, I have to do a roll call vote. Mr. Booley?
Yes.
Mr. Wren?
Yes.
And Mr. Noel votes yes. For the record, couple things. Mr. Booley and Mr. Wren are, and myself are going to be the members participating in the vote on, I think, all 3 hearings tonight, because we weren't present for the September meeting. Mr. Tenori was supposed to be here. I don't know what the delay is. That's fine. We have a 5th member, Lucas Wozniak, who has rejoined the Zoning Board of Appeals. Well, here's Jim. Lucas has rejoined us, but was not a participant in the September meeting, obviously. Lucas, welcome back. To the extent that's appropriate. And you feel welcome, I'm sure. Except it wasn't like this the last time, Lucas.
No, it wasn't.
For the first time in all my years on the board, I think we have 5 members. So that's good. That's a good thing. Okay, we've opened, though, the continued public hearing. And Jim, you weren't present for this the last time. Thank you for being here there. Mr. Tenori here also.
Yeah, real quick, I should mention, Paul, I have that form. I just wasn't able to get it to today. I was out on the road all day.
Okay.
So I signed it, but I did, as this is being recorded, I did watch the video.
Okay.
and I got myself up on the meeting I missed.
Okay, but we'll have to turn that into the clerk. So as it hasn't been recorded with the clerk, I don't think you can participate on these items tonight.
Really?
Well, but we do have the members who were present the last time.
Yes.
Mr. Brad, Mr. Booley, and myself.
Correct.
So those will be the 3 voting members anyway.
Okay.
Okay, we've just opened the continued hearing on the appeal of the building inspector's decision for 157 Mansfield, the Norton Mobile Home Park. Since that last meeting, the applicant has filed, I think, some further papers and expects that will be taken as an application for variance relief. Is that correct, applicant? And who's speaking for the applicant first?
Hi, I'm John Sullivan.
John Sullivan, thank you.
Mobile Homes. Is my understanding, talking to with Paul, we submitted that as, in essence, a standalone request for the variance relative to Lot 38 at 157 Mansfield Ave. And I think we sent the document along there that outlined some of the history and some of our thoughts on that. I want to express my gratitude to the board for, as we spoke at the last meeting, noticing the dire circumstances of the potential tenant here who had already purchased his unit. And I very much appreciate you scheduling this in between your scheduled meetings. I appreciate the thoughtfulness and the kindness there.
Okay, so First of all, I want to note for the record my displeasure at having two applications filed for the same relief. However, in consulting with counsel, apparently that's not prohibited. We'll take them up one at a time, and it may not be the identical relief sought in each one, but the effect is the same. And I think it's a poor precedent, actually, because every applicant could theoretically, if they've been turned down by the building inspector, come in on multiple rounds, making our job that much more cumbersome and somewhat confused. But we'll proceed first on the continued hearing on the appeal of the building inspector's decision. Town Council Amy Quessel is here with us tonight. Having reviewed the record and the submission, she's going to assist us, and I invite any of the members to inquire of council of whatever they want. What we have, and I'll just recite what we had before us 3 weeks ago. We had Mr. Carmichael's cease and desist order. The date is listed in the letter. I have it among my papers somewhere, but I'm not sure of the date. Regardless, it was a cease and desist order to placing a mobile home on lot 38 in the mobile home park. And we determined, well, we heard evidence that lot 38 had been, there was a cement pad there, but lot 38 had not had a structure on it for, I think it was 20 years. I'm not sure if we had established that date exactly. Mr. Sullivan?
That was what a neighbor told Mr. Carmichael, but they're in error. It's although it's still more than the 2 years Mr. Carmichael voiced. It's been 12 years.
12 years. Okay. Yes, I think you corrected that last time, and thank you for refreshing my recollection. So before us is the building inspector's determination. The applicant has come in to ask us to overturn that determination. I will ask members first, Mr. Wren or Alan, Mr. Booley, do you have questions for the applicant pertaining to this application? If not, then I'll ask Mr. Sullivan to add what he wishes to add.
It was my impression that the reason you have two things in front of you is that where we were talking last week was we were dealing specifically with lot 38 and not the global basis of the park, and that the discussion about setting up this interim meeting was so that we could address just lot 38 and actually file something asking for relief for 38 because the potential tenant went out and bought this coach based on the history of what we had done before in the park, and so that we were just and then we expected that we were scheduled for next week's hearing for the what the initial variance request was, or the application to discuss the park in general relative to the building inspector's decision. So I was under the impression tonight was just to deal with lot 38 to see whether or not we can be granted relief so that Chris McGowan, who's on the call with us, would have the ability to move a coach in there and something that would be a non-detrimental basis. We're looking for the typical variance, which is
no, you're not. You asked for two hearings. This first hearing is on the continued application to overturn the building inspector's decision. We asked you specifically last time, how do you want to proceed? You said you were going to file a separate application. They're both listed on the agenda. You received notice. The first hearing is on the application to overturn the building inspector. Members, do you have any disagreement, Mr. Wren or Mr. Booley?
No.
So I just Paul.
Wait, Mr. Sullivan.
I'm sorry, Tom.
Let me conduct the hearing.
I'm sorry. Yeah.
Mr. Booley?
I agree.
Oh, thank you. I saw you positioned to speak. Okay. So the first hearing that we have is whether or not to overturn the building inspector's decision. We asked the applicant to set it up for us, and the applicant set it up for us. I'm not now going to switch back and forth.
Well,
Amy, do you have any reason to correct me in this? You were at the last meeting, but you're familiar with the record.
Correct. I've gone through everything, Mr. Chairman, and there's absolutely zero basis to overturn the building inspector's decision. So there's a variance that is required. There's a finding that's required, and that is taking the entire park into consideration, not just lot 38. I don't know where that came from, but the building inspector did the right thing. He can't issue any permit without relief from this board.
Okay, I don't disagree with that advice. Thank you for the advice, Ms. Quessel. I don't find anything in the record to tell me that Mr. Carmichael's cease and desist was rendered in error. Additionally, we asked the applicant last time, 3 weeks ago, about town licensure, and we since asked the health department for the status of the license for the mobile home park in general. Is it correct, Mr. Sullivan or council, that there has not been a license in effect for the mobile home park from the Norton Board of Health since 2016? I
believe that we were, but I had somebody, there was a different trustee for this up until earlier this year. And so I had assumed that they had been doing their job, so I was not aware of that. I will look into that.
My information is that it's supposed to be, I don't know if it's supposed to be renewed annually or biannually. I'm not sure of that. But that the health department had communicated with the mobile home park several times about submitting a plan, an application and a plan, and that hadn't been done for, I don't know if it's 4 years or 5 now, but I cite that as an additional basis for my feeling that the building inspector was absolutely right. Mr. Carmichael, who's here tonight, came in and told us about a history of the applicant or its predecessor. I'm not trying to hold anybody present responsible for past actions. Mr. Carmichael has told this board that several times over the last years, he or predecessors have tried to step in, and changes have been made at the park that Mr. Carmichael disagreed with, and that this was in process before he had any inkling that an application was going to come in, and that was one of the reasons for his cease and desist order. Mr. Carmichael, am I recalling that accurately?
That's correct, Mr. Chairman. Mr. Sullivan was in the process of installing it, and I was given a tip by one of the residents that he would be installing it. I was told on a Friday. I contacted Mr. Sullivan, who has been the contact of record for several years, and I did in fact speak with him, and he in fact told me that he was in the process of installing it on a Sunday. And I then relayed the cease and desist that Friday via email, and then followed up certified mail.
Mr. Chairman, if I may,
yes, please.
We did receive correspondence from the Board of Health, which indicates that in April of 2016, Mr. Sullivan said he submitted rules and regulations to the state for approval, but they had objections to them. Mr. Sullivan was to have his attorney review them and send us, and the state corrected ones. Since that time, Mr. Sullivan has not returned the applications sent to him for yearly licensing. So it appears that since 2016, the Board of Health has been also dealing with Mr. Sullivan. And the Board of Health is the licensing agent under Chapter 140, Section 32B. So they're the ones that have relayed to us today, confirmed with us today, that there is no license for this park.
Thank you. I appreciate that explanation of the licensing requirements. That's something we don't deal with at the board.
No.
Yet I think that's a factor that fully supports Mr. Carmichael's decision at the time in April or whenever it was, April or thereabouts, to issue the cease and desist because he didn't see things there that were in compliance with the town's bylaws and regulations. So I'll give the applicant a opportunity to rebut any of these facts, but otherwise I'll ask I'll ask the board members if they have any questions of the applicant. Go ahead, Mr. Sullivan, or whomever is speaking.
Yeah,
for
no, thank you. I'll speak. We had up until, as I said earlier, a trustee whose responsibility was to go ahead and follow through on that, and this is news to me, but not that surprising, which is one of the reasons I was moved into the trustee position. So I will. We had, what I recall from 2016, there were 2 or 3 sentences that the Attorney General's office had pulled out. We had then resubmitted and had not heard back from them. And I'll check with I will try to get in touch with the previous trustee. But if that's, I was unaware, and I certainly did not want to have that be a circumstance. So we will rectify any licensing situation, any rules and regulations situation. Historically, it had been with the AG's office that if you didn't hear back from them, then they didn't get back to everybody, and there was the assumption that the rules had passed. So we did. Currently, they no longer operate that way. They operate on wanting you to present a Word document that they can mark up, and so the technology has been incorporated, and there's much more feedback on that. So I was. I'm surprised. I'm surprised and not surprised, and I apologize for the lack of licensing there. The license is granted every year. It's a $100 fee. It's licensed for the 56 units that the park has had for many years. In my discussions with Mr. Carmichael, that was not brought up at all. What he had mentioned was his concern about the non-conformity, which is what we had wanted to address. And I thought what I had submitted right after, the very next day after our previous meeting, and discussed with Paul, was to put the concern about the building inspector's decision to continue it to the next hearing, which is going to be next week. And the rush was to get this in so that we could deal directly with Lot 38. I can see where the concern about the building inspector, the Board of Health license comes up. In discussion with potential tenants and other tenants, the building inspectors mentioned that we'd run afoul of not testing our septic systems or something of that sort, and I've never been able to get a clarification. There seems to be, he's made reference to other things that we supposedly have not done, but has not told me what they are. And I'm in the dark. Mr. Carmichael, can you tell me what the concern was about the septic systems?
No, we're not here to go over that again.
Okay,
I'm sorry. If you want to bring that up in the next hearing, you can, or you can call Mr. Carmichael on, when there aren't 15 people here. But we're here on a very narrow issue, and with all due respect, Mr. DiGiuseppe asked in an email, because I asked him to ask, what are they doing? Are they putting one on hold and because they want to go with the other? Because we don't want to do these in tandem. And the email back was, no, we want to hear both of these. So we're hearing both of these. The first is the building inspector. The agenda's been posted for, a week and a half now. So with that, members, do you have questions of the applicant or the applicant's representatives concerning overturning Mr. Carmichael's decision of April?
I have nothing specific to the appeal, more for the variance when we get to that.
Okay. I just had a question for
Alan?
I'm sorry.
I was trying.
I'm sorry. David, I'm doing the Hollywood Squares thing, and I'm not doing it very well. Mr. Wren, do you have any specific questions?
I really don't at this point. No.
Okay. Mr. Sullivan, go ahead.
Then I'll shift gears and we'll move towards this. What I had noticed through some of the hearings that I'd seen on video and also at our last hearing, which I know was time compressed because of the agenda that you had, it seemed like there was some confusion on board members in terms of how a mobile home park actually operated and the constraints on it. And I wonder if any of the board members had any questions for me, because it's not a standard real estate circumstance. There's no permanent houses there, and I'd heard that the board had been looking at trying to figure out how to apply standard zoning regulations to something that can be moved in and out on wheels. Are there any? Does anyone have any?
Okay, so I ask you to address the chair.
Okay.
I will forward the question on. However, I will point out that that is something that will come up in the next hearing, which we've scheduled right after this hearing for tonight. So again, that's a separate issue. This is an issue as to whether Mr. Carmichael, our building commissioner, made the right decision based on the evidence before him at the time.
Mm-hmm.
Members, is there a motion to approve the application to overturn the building inspector's decision from April?
I'm not.
And if I could.
I'm not going to comment on that then.
No, Mr. Sullivan, hold on, please. Members? The motion can be made in the affirmative or the negative. Mr. Booley or Mr. Wren, do you have a motion at this time, or do you want to hear more on the building inspector's decision?
Please.
I would make that motion.
Well, can you state the motion, please?
I would make the motion in the affirmative to repeal the building inspector's decision.
Okay. Is there a motion to close the public hearing?
I'll make a motion to close the public hearing.
Mr. Wren has made a motion to close the public hearing. Mr. Booley, do you second?
I second, as long as you can hear me. I'm jumping.
I can hear you. Yes, we can hear you fine. Thank you. All right. That motion is up for discussion among the members. Mr. Booley, Mr. Wren, is there anything else you want to hear as to this issue, overturning the building inspector's decision from April?
No.
I have no questions.
Okay.
Mr. Chairman,
I
I just have a quick question. The motion was to repeal the building commissioner's letter?
Yeah, it was made in the affirmative.
Okay, just checking.
There's a motion pending now to close the public hearing first. I realized I hadn't done that.
Okay, thank you.
So I asked for that first. I'm gonna one more time give the applicant an opportunity while this motion is pending to close the public hearing. Mr. Sullivan, briefly.
I appreciate it. Thank you, Mr. Chair. As we move into this motion, which was not what we thought we were dealing with based on a conversation with Mr. Di Giuseppe, I wanted to, we had submitted documents that town council, I hope, had reviewed. In this particular case, it made reference to an SJC court that dealt with Shirley Wayside that specified that mobile home parks did not, individual lots within mobile home parks.
Sorry, Mr. Sullivan. I'm sorry. I'm going to cut you off because that's not relevant to this decision. I don't believe.
Absolutely. If the building.
Okay, I'm going to cut you, Mr. Sullivan. There's a motion pending to close the public hearing. It's been seconded. Mr. Booley, how do you vote on closing the public hearing?
Yes.
Mr. Wren, how do you vote?
I vote yes also.
And Mr. Noel, for the record, votes yes to close the public hearing. Mr. Booley also made a motion to, I'm sorry, I'll state it in a twisted way, to approve the application to overturn the building inspector's decision. So a yes vote would overturn, would support the application of the applicant to overturn the building inspector's decision. A no vote would cement the building inspector's decision, would approve the building inspector's decision. Mr. Booley, do you vote? How do you vote?
I vote no.
Mr. Wren, how do you vote?
I vote no also.
Mr. Noel votes no as well. So the application to overturn the building inspector's decision is denied. we will have a decision within the allotted time on that matter, and we'll post it accordingly. Next on the agenda is another public hearing for 157 Mansfield Ave, number 38. In this, the applicant seeks a variance to allow for a mobile home in a commercial zone. I believe we have the same people in attendance for this public hearing, so we will move to that. We've opened the public hearing at this point. A further, I didn't see a second application. In other words, it says Zoning Board of Appeals application. I saw a memo that was submitted the day after our last hearing. We can treat that as an application for variance. The application, in my view, did not state the variances being applied for. We had discussed generally in the last hearing that we needed an application to state specifically what relief was being sought. I brought up 1.5E. I believe I brought up 1.5E because this is a non-conforming lot and or structure, and suggested, didn't they need to apply for 1.5E determination that this would not be substantially more not conforming? Now, in the past, and I think council is in agreement here, we take these applications and read them broadly. We have in the past said, well, here's what you really need here. Even though you apply for variance, you need a 1.5E, or the other way around. And I'm not opposed to doing that tonight as well. But I need to ask, I'll first ask the applicant, what variance relief are you looking for?
So we actually, on page 2, we spelled out 1.5E. We were looking for the ability to put a mobile home park on, not park, a mobile home on the lot in light of it being a non-conforming structure, if you will.
And that's a determination under 1.5 of the zoning bylaws. I understand that.
Mm-hmm.
You had styled it or said it was going to be an application for a variance. I'll help the applicant out here further by looking at the plan of record. And for the record, the plan of record is by RIM Engineering, and it's dated August, I think it's 28, 2020. That's the only plan that's been submitted, correct, Mr. Sullivan?
There was a small amendment to it. I don't know if they dated it, that it was sent to Paul, that moved the coach 15 feet away from the back lot line. I don't know what it shows on yours.
I've not seen any such thing.
Okay, so Paul had received that, and it had verified via email that he received it a couple days ago.
Okay, this was what was advertised. This is what was publicized.
Okay.
So if you're saying that there's now a new plan of record, I don't have it in front of me. Paul, if Paul has it, I'll ask that he email it. But are you suggesting then that the lot 38 position is intended now to be 15 feet off the side yard?
Correct. 15.1 feet off the side yard.
Okay, this has it in a blow up down at the bottom of the plan that is dated August 28. Mm-hmm. It has the concrete pad at 12 feet 4 inches, and the proposed structure at 12 feet. Actually, it is 12.4 feet and 12.7 feet for the structure off the side yard line. Mm-hmm. That I assumed was the variance relief that the applicant was seeking. If there is a new plan of record that we haven't seen, I don't know what variance relief is being sought. I think it's an application for a 1.5E determination. Amy, can you help me out here?
Sure. Thank you, Mr. Chairman. So the use here is a pre-existing non-conforming use. Now, if this were licensed, which I do need to correct Mr. Sullivan, who said that he gets a license every year, that is not true. There hasn't been a license issued since 2016. Paul and I confirmed that today with the Board of Health.
Understood.
So there has been no license issued. So it is not a pre-existing non-conforming use containing 56 units, because Unit 38 was abandoned 12 years ago. So we don't know how many units are there at this point. If anything, there's 55 because they were licensed for 56 and they lost one. We don't know if they've lost more. Now, to put an additional unit onto this non-conforming use, they would need a finding under 15E. Now, we were provided paperwork. Mr. Chairman, you are correct. We were provided on August 4th. We were provided, and I do have an application that was received August 11th that says request for a variance, but it doesn't say anything else. It doesn't say what they're requesting a variance from. So I went through the whole file, and the plan that you referenced shows the structure 12.4 feet from the side lot line when it should be 15. So because this is not a 1 or 2 family dwelling, it doesn't enjoy the protection of 48 Section 6 as a single or 2 family dwelling, and therefore under the Rockwood case, it would need a variance to be within the side setback. Now,
Can I just interrupt for 1 second? And I'm sorry, Amy.
that's okay.
This is Jim.
Yes, Jim.
Mr. Chairman, there is in our Dropbox, and I don't know if you are aware of it, there is a plot plan from RIM Engineering dated October 6th, I believe. And if you look on that one...
I have not seen that.
Yeah, it's in the Dropbox. And it's dated October 6th. And it does, if you look at the bottom, it does show the mobile home being, I don't know why I can't zoom in right now, but I think it's 15.1
Okay.
off the side setback. And that's the only reason why I interrupt, so I apologize.
No, I appreciate that.
But if that's the case, Mr. Chairman, then
Yeah.
we need an affirmative
Right.
request for a variant. I don't know what the variance request is. We're then stuck with an issue of the advertised hearing does not in any way match the relief for request, the request for relief, sorry. And so we might not be able to push the Duteau case that far. The Duteau case said that provided the public knows what the applicant is seeking relief from, you could change the form of relief. I mean, the application was for a variance, meaning that there's some kind of requirement of the zoning bylaw that will be varied by this board or allowed to be varied by this board. Here, if they're proposing this new plan, which I haven't seen either, then we're looking at a finding under 1.5E, which is, again, that's the reason why the previous application was denied, because the building inspector denied it because there's no matter what, there's a finding required from this board. We were under the impression there was other stuff required too, and then again, we still have this issue of no license.
I hear you, and I appreciate that. I'm looking in the Dropbox, and I just went to the Dropbox link that was in the email from 10 days ago, and I can't see it, although I may not be well, here's the meeting. Oh.
It's under 157 Mansfield Ave, number 38, appeal folder.
Okay.
And if you go into applications, it's in there.
Jim, thank you. You are a detective. Pardon the reference. Okay, now I see there are 2 maps here. I'm just going to download it so I can look at it for the record, describe what I see. I couldn't see the posted one very well on the screen. Well, I can't see the date on it. Can you, Jim, did you say it was dated October 6th?
I could see on the bottom,
the signature. The signature.
bottom right-hand corner, right above rim, where the
Yeah.
seal is.
Looks to me like October 2, but I can't tell.
You're correct. It's October 2.
Is it 2? Okay.
Okay. And this one, well, this still shows, the blow up still shows the pad 12.4 feet.
Yeah, that's correct. The pad's 12.4 feet, and the proposed, I guess that would be the mobile home, which is in shaded,
Yep,
would be 15.1.
15.1 feet off. Okay, so the proposal is to slide the mobile home a couple of feet further off the sideline setback where the pad exists at 12.4 feet. If I summarized it correctly, I hope I have.
I believe that's correct. And
That was not the plan of record until at least October. Well, wasn't the plan of record on the application that was advertised. In any event, hold on, I'm trying to get the Zoom screen back. Here we are, I'm back. But I still have the same observations that, number one, it's not a request for a variance anymore if you go with the new map, because what dimensional requirements are being varied from, to use poor English.
So I think we have to have confirmation from the applicant on that, because they did apply for a variance. So under what section of the zoning bylaw are they requesting a variance from?
So
Go ahead, Mr. Sullivan.
I think that's a good point, and what we were looking at is that it's interesting, the zoning bylaw in 1977 was changed so that it prohibited mobile home parks. It doesn't prohibit mobile homes, and actually, as a matter of fact, mobile homes are permitted on any other lot in town besides the mobile home park. So what we were looking at is we were looking for a variance to allow us to put a mobile home in that location, because it is amongst a series of other mobile homes and would not be detrimental to the neighborhood, and that the zoning board has the ability to grant that relief from there. So that I'm not, we weren't looking for side setbacks. We were looking for the ability to put a mobile home there, even though the town unclearly says that mobile home parks aren't allowed, but we were stating that we would like to put a mobile home in that location. And I'm not clear why. Well, so I'd like to hear your interpretation of that.
I'm sorry, are you asking me?
I am directing things to the chair. I think.
Sure. Okay. My concern is that I think what council is saying is a variance request is for particular relief requested, and the applicant has to state clearly what relief is being requested. I think you're not requesting a variance in the bylaw that says you can't put a mobile home park here because there's already a mobile home park there. You're now, if you go under the new plan, you're not requesting a dimensional variance for the side yard setback.
Mm-hmm.
So it seems to me like no variance is being requested. What's needed, what you're asking for, is a determination under 1.5E that this will not render the use substantially more detrimental. Will you confirm that for us right now?
Yes,
That's what you're thinking?
I addressed that directly on page 2, second paragraph of the letter that you got, and with the pointing that out, that in other words, we're looking for somebody to be able to move what's in essence a glorified, a trailer into that position for relief under 1.5E. That because it's not detrimental, it's among other mobile homes. It's next to a strip mall. It's across the street from another mobile home park. It is hundreds of feet away from the road and the back lot line. And so we're looking for the ability to put a mobile home for Mr. McGowan in that location? Is there, and requesting relief from 1.5E, in that case?
I don't think that's a variance, Ms. Questle. That's not a variance request, is it?
No, absolutely not.
Okay, so it's a request. I mean, if we want to read this broadly, it is a request for a determination under 1.5E. It is ill-styled as a request for a variance, even though that's what the applicant said at the last meeting it was going to submit. That's what I see.
Right. So I think that the hindrance that you have here is that the paperwork that I saw, which was dated back to
August.
There was some that was in May.
Yes, there was.
Where the paperwork states that this is a non-conforming use with 56 licensed mobile homes on it. We do not have that. We do not have a license. Therefore, we don't know how many. The board doesn't know what the extension of this non-conforming use is. So is adding one mobile home are we adding it to 55? Are we adding it to 46? We just don't know because we don't have a license. There's no license.
Right.
So
I'll suggest that the plan of record, either the plan of record or the amended plan that members are just seeing for the first time in the last 10 minutes, I counted out, and it looks like there are 56 depicted here, but the 56th would be lot 38, D38, which has been vacant for 12 years. There is a concrete pad there now, but not a structure, not a building. So, again, I think that this is a request for determination under 1.5E, whether this will make the use substantially more, not substantially more non-conforming, so as to offend the surrounding environment. The same factors, I think, apply here. The same facts apply. There's no license in effect for this. So how can we, when we are imbued with the responsibility to make decisions for the health and safety of the town of Norton, even consider that? It's not what the application states. The letter does state that. The letter includes 1.5E in the letter. But the application, we were told, is for a variance. Regardless, if we consider it an application under 1.5E, I don't see how this can be not substantially more non-conforming. And I don't know how we could render a positive decision for the applicant.
So,
that's my
question.
Go ahead, Mr. Sullivan. Yes.
So if it sounds like we'll probably ask to, and I'll check with my counsel whether we withdraw this or we will continue it. It sounds, and I understand the logic because I'm frankly a little as prone as you are regarding the lack of license here, which is primarily administrative. In terms of if the license situation is resolved, do you have a recommendation on what you would be looking for if this is not the proper way to apply for that? And as I'm missing, I thought 1.5E was the appropriate way. Do you have a recommendation on how we would apply for that?
That's going to be up to you and council to discuss. We have what's before us. That's what we have to decide on tonight.
And then the other question I had, and you put town council to weigh in on as well, is that there's a very strong case. This park pays for 56 mobile home sites per the assessor's office. Has been up until 4 years ago licensed for 56 units. That seemed to be there's a lack of communication there. Sends an excise tax in for 56 units, and pays. And I'm just wondering, where I'm seeing this leading is the potential for the town stating that the lack of use of a pad is would come under 1.5C when a pad is just the pad. And these are mobile home units. They come in, they come off they're campers. This is in essence a glorified camper that has single-family regimens being applied to it relative to improvements. And I was just wondering, I assume Ms. Questle had a chance to review Shirley Wayside and so forth, and if she sees any contrast between that ruling and the idea of us losing lots, even though we had been licensed for them. I'm just and that we've been paying taxes on them. So I direct that to the chair if you could so kind to ask for Ms. Questle's opinion on that.
Okay, first of all, under 1.5E, 1.5C speaks to a building. If a non-conforming use is discontinued for a period of 24 months, or if a non-conforming building remains unused for 24 months, there's no building there.
Correct.
There's no building. It's a concrete pad. I don't know what's beneath that. You had said last time you thought the utilities were still there. I don't know that.
No, I know. I maintain the utilities.
Okay.
So my whole point was that...
So there are pipes and utilities there.
Yeah, that it is precisely not a building and therefore not subject to 1.5E, 1.5C in terms of losing its status. And as we've maintained that pad, and that's the overall park itself. With that, I don't want to get in over my head, so I'm going to, I was asking for guidance that once we resolve the license issue, because it will indeed be resolved. There's no way for this to be just, we can't ignore it, but neither can the town ignore it. We will definitely be right on top of the administrative details necessary to get that license. Then we're also looking at the fact that we have a history of this, and it's a multi-decade history of this being a 56-unit mobile home park, and whether there would be anything involved relative to our inability to put. We have 4 lots there currently that we have maintained, but they were not buildings. These things are on wheels. They're mobile. So with that, and I know that part of this is hard for many people to comprehend, which is, and the easiest way is to say this is a glorified campground. Whether there's a coach on the pad or not does not mean that it's no longer a viable location. With that, I'm going to ask the chair to recognize Robert Krause, who is the legislative liaison for the Mass Mobile Home Association, and have him available for questions, and he can also hopefully bring a little bit of elucidation into this. Thank you.
Members, before I move on to Mr. Krause, do you have questions of Mr. Sullivan?
No.
No, I don't have any questions.
If I just one more thing, Tom, if I may.
Yep.
This is a very vibrant and viable community that addresses low and moderate income homeowners without any subsidization. We as taxpayers don't have to pay anything towards it. And it's a very, very nice neighborhood. People look out for each other. I would say that it has probably more communication and interaction among a primarily elderly population than the average subdivision, where people may not know who their neighbors are. And it's been there for, it looks like, at least 70 years. And we're just, part of the reason that I wrested control from it was that we want to make improvements there. We want to make it an even nicer place to live. We're aware of we encounter some prejudice from some town people in terms of mobile home parks in general, but we are looking to improve the looks of the street. We just would really, our ability to run this is based on the rents that we get, and it's a family business. It's not a corporate thing, which there've been many things written about that. And so this is a very personal situation that we're trying to improve, and there are a bunch of legalities to it, but the state is very, very much in favor of maintaining mobile home parks. As I believe a number of you have been made aware, it is very hard to close a mobile home park down. The state doesn't want them to disappear because it fulfills a major housing need.
Mr. Chairman,
Yes.
if I may, I think that what I have to say is going to extremely abbreviate Attorney Krause's comments, because this is recognized as a non-conforming use. The entire park is a non-conforming use. The town is not disputing that. The town is simply saying that this non-conforming use is going to be expanded by putting on this one extra house, because it lost its non-conforming status under 1.5C, because 1.5C, as Mr. Chairman, as you correctly pointed out, regulates buildings. In the definition of building is mobile home or manufactured home. So therefore, this is simply a finding before the Zoning Board of Appeals. If I may, the applicant has created this confusion, but this is a finding under 1.5E, whether one mobile home will increase the non-conforming status of this park to be a detriment to the neighborhood, when 12 years ago there was this mobile home there. It's just no longer there, so they have to come in for a finding. Now, the stumbling block that they have is the fact that there is no license. So if Mr. Sullivan is going to pay the $100, get the license, then when this can be continued, come back, and it's simply a finding. So we don't really need the history of mobile home parks or manufactured homes. We don't need to know, what the assessors had, what they didn't have, because the license, and which was referred to, I counted 4 times in the paperwork, that this is a licensed community, and that is its non-conforming status, its use as a licensed community. So it's not. It's a non-conforming use for 55 mobile homes that's being increased by 1. It's really not, that it's not a variance. It's not anything. That's what it is. The building commissioner was correct. He could not issue a building permit without a finding, at least from this board. And then the applications came in that just confused everything. So, I would just recommend that once they come back with their license, you guys can take this up as a finding, as you guys have done numerous times in the past on other projects.
I think that is crystal clear that this is an application, if we consider it under 1.5E. There's nothing else to consider.
Correct.
So, Mr. Krause, do you have anything to add under that parameter, that this is a request for a determination under 1.5E?
Mr. Chairman, through you to your board and to your counsel, I don't disagree with your counsel, other than the fact that the characterization of it as an expansion of the non-conformity when and the license, which is subject to simple renewal and has consistently and historically been 56 units.
Sorry, Mr. Krause, you're electronically frozen. Anybody else? Mr. Krause appears to be frozen here.
Once we...
Now, sorry. I'm going to direct my comments elsewhere. I think I understand the argument from Mr. Krause that this was 56 units. We acknowledge that. There's no question about that. But that also expired at least a few years ago, and there's been no license for 4 or 5 years. Members, do you have any other questions for the applicant on this application for determination? Mr. Wren, Mr. Booley?
I do not.
Mr. Chairman, my only question would be, once in the next meeting, if we make this finding, the next time they would like to put another trailer, they would just state, Mr. Sullivan just stated there's 4 other empty lots. How long have those been empty for? Do we have to go through this all over again?
You know what? I thought I heard that as well, and I wasn't sure about that. That's how many empty pads are there?
So there are 4 empty pads due to market forces and so forth, and
including this 38,
including this one. And so what I'm hearing is the potential here for us to withdraw this and to get the proper licensure. And then, if you could help me out, then if we came forward to put mobile homes on those existing pads, if they're properly licensed, how would we be asking zoning for that? Would that be?
Okay. As I said before, that's a matter between you and your counsel.
Okay.
We can't give you advice as to how to proceed.
Mm-hmm.
The applicant, I think, is asking us to continue this. I don't know if members want to continue this or want to take a vote now. This has been in process since April.
We
had
have
it on our agenda twice, I think 3 times, except that then it was taken off our July agenda maybe, and then put on September and now October. I'd entertain any kind of motion right now to approve it, to continue it, whatever is appropriate, whatever the members wish to do. However, I will point out that from what we've heard at this hearing and last month, there is a process to licensing. That process was broken 4 or 5 years ago, and that it involves AG, Attorney General comments, and then responses to Attorney General comments. And then a submission to the town of apparently approved plans or regulations. I don't know how long that takes. It doesn't sound like it takes 2 or 3 weeks. It sounds like it takes months to me. So I'm just thinking, do we really continue this or do we take a vote tonight? Members, how do you respond?
I was wondering whether we can withdraw, number one.
Yeah.
That's an option.
Oh, I see. So the applicant is asking to withdraw the application now.
Without
okay.
prejudice, Mr. Chairman.
Members, is there a motion to withdraw the application, which is stated as a variance, but we are treating as a determination under 1.5e? Is there a motion first?
Mr. Chairman,
Yep.
the applicant has to request with or without prejudice, and I would assume that he would request without prejudice.
I heard Mr. Sullivan say without.
Oh, okay. Sorry.
I would like my attorney to at least have a chance if his technology is working to be heard, please.
Mr. Kraus, do you have a position on the withdrawal?
Yeah, Mr. Chairman, with respect to you and your board, can you hear me now?
Yes, I can. Thank you. You were completely frozen a couple minutes ago.
I'm sorry.
Nothing to apologize for.
Well, all I was saying is that I appreciated Council's position, your position. I think through this process, Mr. Chairman, even though it's taken some time, we've been able to hone down precisely what it is you wish, and we'd like to withdraw without prejudice. And come back once we square away our license issues and address the 1.5e or 1.c issue head on with you.
Okay.
The 1.5e and 1.5e or 1.5c issue with you. And we will streamline it for you.
Thank you, Mr. Kraus. Town Council, Ms. Quessel.
So if
An applicant can request a withdrawal without prejudice, correct?
correct, you have not closed the hearing yet, so
Right.
yes,
And we have an option.
you have to vote to accept the withdrawal because you've opened the hearing, so you do have a choice whether to accept the withdrawal or not.
Okay.
But one thing I did want to point out is that this board already made a decision on upholding the building commissioner's decision. So there really is no need for a 1.5c argument unless Attorney Kraus wants to file a complaint in court, because that's already been taken care of. So I think if we're going to streamline things at the next hearing when they come back, I think 1.5e, it's all right there. I really don't think that we need to get into anything else. That would be the most advantageous for everybody, I think.
Thank you. Members, is there a motion to permit the requested withdrawal of this application without prejudice? Meaning it's off the table as of tonight. The applicant can come back at any time with whatever application it wishes to proceed on after it's straightened out the licensing issue, if it's able to.
I'll make that motion.
Mr. Booley made the motion. Mr. Wren, is there a second?
Yes, I will second that.
Okay. We have the option, of course, saying no. We've been through enough here. I don't recommend doing that. I think we should give the applicant a chance to come back when and if they're able to square away the issues that we've identified. There's been a motion, it's been seconded. Mr. Booley, how do you vote? Yes,
Yes.
to allow the withdrawal without prejudice?
Yes.
Mr. Wren, how do you vote?
I'm also a yes.
I vote yes as well. Okay, thank you, everybody. Hopefully this will be less confusing the next time.
Yeah,
Thank you, Mr. Chairman. Thank you all.
Thank you. Mr. Cross, Mr. Sullivan, thank you.
Bye-bye.
Council, thank you. Can you stick around for just a couple more minutes? We have one more item that,
Correct.
right, thank you. I'm gonna shut off for just 1 second because I'm gonna grab something to drink. We don't have to take a recess. I'm just gonna electronically disappear for one moment. And we'll go to our next agenda item, which is 1 Greatwood Circle in about 30 seconds. Thank you. Okay, thank you. I'm back. Members, you ready to proceed?
Yes.
Okay. Next on the agenda is the application continued from our last meeting, September 16. Property address is 1 Greatwood Circle. Applicant seeking a variance for relief for lot frontage and lot size. We may have narrowed that down to lot size. I'm not sure. We'll revisit that briefly, perhaps. Is there a motion to take this from the table for further consideration?
I will make that motion.
I'll second it.
Mr. Wren, how do you vote?
I vote yes.
Mr. Booley?
Yes.
I vote yes as well. And who is representing the applicant tonight?
Good evening, Mr. Chairman. I'm going to be representing him. My name is Chris Vale. I'm an attorney for the applicant.
Thank you. This was an application that came before us to divide the lot. Well, that's not the relief they're seeking from us, but it's for a variance for one of the 2 lots. I'll say for the second lot, the lot on the right, as it's depicted on the plan of record. And we've encountered this type of application a couple of times in the last year. The next step would be to go to the planning board, I guess, for an A&R, if that's the proper term. We recognize this as having come up before and asked town council's advice. Mr. Veal, what is your applicant's position tonight? Is this request for a variance for frontage and lot size, or just one?
It would be for frontage and lot size. From my understanding is he would like to subdivide one plot, or the existing lot that was originally frontage was on Smith Street. However, with the creation of Greatwood Circle, he'd like to divide that lot. One of the lots would be conforming with all of the town of Norton's ordinances. However, that second lot is missing approximately, I'd say 9,000, a little bit over 9,000 square footage, as well as about 9 feet in frontage if it was, which is our plan, to put the driveway and frontage of the house on Greatwood Circle. However, as you can see, the frontage could also, I know the town of Norton does not adopt that, but the frontage does wrap around with the Smith Street. So that's why we are looking for both the variance for those 2 ordinances.
Thank you. And for the record, the plan of record that we we had before us the last time and this time is Jacobs Driscoll Engineering, dated July 15, 2020. Lot 1 is shown to be 40,000 square feet with 150 feet of frontage. Lot 2, this is in an R40 zone. Lot 2 would be 31,901 square feet with frontage on Great Woods Circle of, looks like 141 feet. There is adjoining frontage on Smith Street of some almost 90 feet. I was just wondering whether those frontages get combined or not. I don't think they do. I think we'd have to have special exception to that in the bylaws. But in any event, I just wanted to clarify what the two variance points were. However, having considered a similar, though not identical application just a few months ago, we asked town council to take a look at this. Ms. Questle, you've reviewed this application and plans, and I'd ask you to state your findings or what your advice to the board would be.
Sure. So as this board knows, because we just went through this, the zoning bylaw, the requirements for a variance exactly track the statute, 40A Section 10. There are 3 prongs that are required: soil, shape, topography. The next one is hardship, and the next one is if the relief can be granted without substantially derogating from the intent and purpose of the bylaw. So this proposal actually does not meet any of the 3. There is nothing unusual with the soil, shape, or topography of these 2 lots because they are being actually created. Same thing with the second prong, which is hardship. There is no hardship because the hardship is being created by the applicant. There's numerous case law on that. The most cited case is the Whalen case, which says that the applicant cannot create their own hardship. And then the third prong, which is usually the easiest to overcome, in this instance, they're asking for a frontage variance. And so there's case law out there that says that a zoning bylaw, particularly frontage, has to do with, health and safety because of access and things like that. So because there is a frontage requirement in Norton and they're asking for a frontage variance, this would be, derogating from the intent of the bylaw, which is the health and safety and, orderly development. But the real problem, unfortunately, that the applicant, has is that they're creating 2 lots, and one, it's simply not conforming. The planning board would not be able to approve this A&R plan because there's not enough frontage. So the first thing a planning board looks at when they look at an A&R plan is there enough frontage? And then they have to determine if the frontage is adequate. If there's not enough frontage, the plan cannot be endorsed. And so I think that might be why the applicant is here, to get a variance from the frontage. But again, your variance standards under 10.3 mimic the state, which says that, variances are not allowed as a matter of right. They should be granted sparingly. And then again, we have the Whalen case, which says that when you create a hardship, it doesn't necessarily apply as a hardship.
Okay, thank you, Counsel. Mr. Veal, do you have anything to counter what Ms. Questle is advising us? This is how we had proceeded just a few months ago with something on South Worcester Street, and I think again once last year. I don't remember where that one was, but Mr. Veal, I'll give you the opportunity.
Thank you, Chairman. So I did come into taking over this case with Mr. Rosario, who's a licensed contractor, and Mr. Fernandez, who actually I met. He was an employee at Brockton Zoning Board, or the building department actually, in which I know that he is very knowledgeable that we do need to prove a hardship, what Attorney Questle did say. What I respectfully disagree with is that I do believe that this property does have hardship. I do believe that there is that the lot does have a unique size, shape, and topography. with it looking as a not traditional kind of triangle. If you can see, it looks like 10,000 square feet was subdivided off of that lot 2, which was turned over by the Norton Historical Society from my recollection from researching the deeds. Another thing is that I do believe that it would be kind of a safer alternative to put a driveway on a circle, kind of a dead-end road, rather than having it on a Smith Street, which I'm not too familiar with this area, but I do think that that is kind of a unique frontage if you're considering the frontage, which was, I believe, an existing house where the driveway was on Smith Street, which was very, very small frontage area. This is adding more frontage by putting it on Greatwood Circle. However, they are proposing that they build 2 brand new single-family houses, which are pretty much conforming lots. I know that my clients did tell me that you brought up concerns from past cases, primarily being the 133 South Worcester, which I think has some similarities, but very big differences. You're talking about lot sizes that they were trying to subdivide an already undersized lot, in which this lot is, if they were subdividing the 2 lots, I believe one of them was going to be approximately 30,000 square feet. The other one was around 22, I believe, in that decision. You're looking at 2 lots, which one meets all conforming square footage, the other one 31,900. Furthermore, in that neighborhood, I don't believe that there are any abutters opposing this variance. But I did look up to the assessors. There is 4 Greatwood Circle that has a lot of 30,000 square feet. The other is 6 Greatwood Circle, which is 33,000 square feet. So this is conforming to the neighborhood. Additionally, I know that with COVID and with budgets, this would be beneficial to the community by having 2 taxable incomes. I did look at their taxable incomes that are around $7,000 a year that I think would benefit the town of Norton. These aren't just 2 guys just trying to make a quick buck. They build beautiful homes. They know the law. They would work with the town and build 2 very nice homes that would benefit the community, would benefit the town. And the chairman, I do believe the board does have enough to grant the variance on both square footage and frontage, based on the hardship of having a unique size, shape, and topography, which I stated. I know that there is a mention about planning board, but we're just looking for the variance, and then in order to go to planning board, we would work with them in order to get the, I believe it's an A&R approved. But tonight we are looking for relief from those 2 in order to benefit the town and build 2 beautiful homes in the town of Norton.
Thank you. I believe we heard, though, from council that we don't have the authority to grant this type of relief. Members, do you have any questions of the applicant or of council?
I do not.
No, I don't think I do. I guess. So you're looking for 2 variances. One is for frontage, and then one is on lot size. Correct?
That is correct, and that's for lot 2, proposed lot 2.
Right.
The lot
Right.
1 would meet all the requirements. But I do believe that you guys do have the authority to grant relief from frontage. I don't know what authority planning board would then later on have with the A&R, but I do believe that there is authority from the chairman and the board to vote on granting the applicant frontage.
I think I'm sure. I mean, personally, I mean the frontage. I'm not sure which way I go on that, but the lot size is what I guess I'm having a problem with, because it's currently a conforming lot, and you're creating a non-conforming lot. You're creating you're creating the variance.
That is true. We're saying that the size and the shape, we are looking to divide it. Originally, I guess if this was the existing house where the house had the driveway on Smith Street, I don't believe that it would be a conforming lot because it wouldn't meet the frontage.
but that's not what's there now.
That's not
Mr.
what.
Carmichael? Mr. Carmichael?
Mr. Chairman, if I could just give some history of the lot, might clarify a few options for you. So 2 years ago, I condemned the existing structure on that lot. It was over a 200-year-old building, and it was missing the rear side of it, so it was sagging in. So I condemned it. It was torn down. There was a small driveway on Smith Street. I believe the frontage was reduced when that Great Wood Circle was put in.
Yeah.
But the original frontage was on Smith Street. It was an oversized lot. It was conforming at the time. So if that helps the board in its decision, I just wanted you to know the history of the lot.
Okay.
Can I just say one more thing?
Yes.
Completely, we understand why town ordinances and why the town of Norton is a beautiful town that people strive to go to. And the reason why we have bylaws is to protect people that nobody's right on top of each other, like a city. But as you just heard, this was an oversized lot. We meet all the side, rear, set side backs, and it would conform with other properties in that neighborhood, in that circle. So that is why we are asking for relief.
All right, thank you. But again, Ms. Quessel, the case law indicates that we don't have authority to authorize a variance for a hardship that was created by the applicant. I think that's the overall factor that affects the three prongs of the variance consideration. If the applicant is proposing to cause a hardship that he then wants to ask for relief from, that's just a step too far. And I don't fault the applicant for coming to us, but I think it's been explained fairly clearly that we don't have to, and we probably don't have the authority to do that. So that, the zoning bylaw, including lot size, it imposes minimums. The fact that it's an oversized lot is of no significance, I think. It's in a zone that says now you need 40,000 square feet. The fact that it has 71,000 square feet is of no consequence to the application. They're simply asking to be allowed to create two lots, which will create a hardship, which they are then asking for us to apply to grant variance relief. And we
Just one thing.
we didn't do it for an applicant just a few months ago. I think I would urge that we be consistent in that interpretation of the law until we're moved off that position. That's my take on this. Mr. Veal, did you have a response?
Yes, Your Honor. I'm sorry, Chairman. I do believe that the hardship was also brought to them by the creation of Great Wood Circle. That was never there when that lot was there. I do believe that the creation of that circle years later, by now adding a road down the side of his property, is also a hardship that was brought upon the applicant and brought upon the plot.
Mr. Chair,
That doesn't make the hardship that we're being asked to consider, though, because it has appropriate square footage and frontage now on that Great Wood Circle. So I'm sorry that I don't see that as pertinent to override what council is advising. Mr. Carmichael.
The frontage is currently on Smith Circle, Mr. Chairman.
What do you mean the frontage is currently?
The current frontage for that building, that current address is 32 Smith Street. That's the address. So the frontage is not on Great Wood Circle. It's on Smith Street. Excuse me.
Yeah, but can't we say, well, there is frontage on Great Wood Circle, therefore, it complies with the frontage requirement?
I would refer you to council.
It doesn't comply with frontage, though, even on Great Wood Circle. That's the problem. They're proposing
Right.
two lots. They're missing 9 feet.
I agree. It does now. Combined, it does now. It is a combined lot now, and it complies now with frontage on Great Wood Circle.
Correct. So Great Wood Circle, when that came in, that did not alter the shape, size, or topography of the oversized lot, or the original lot, I guess I would say. What they're doing now is they're trying to take advantage of Great Woods Circle to get frontage for 2 lots, which I think is fine, but unfortunately they don't have the frontage, and this is a variance. And under 48 Section 10 and under your bylaw, a variance is extremely hard to prove.
Chairman, can I ask, so if they were to build, because frontage is on Smith Street, would they be allowed to put the driveway in Smith Street, or would they have to come back to a board and have to go through Great Woods Circle? We thought that this would be a much better plan, so it's.
I don't know. I mean, I assume that plans would be submitted, and any rational person would probably put a driveway in Great Woods Circle, but I don't know. I don't know what the plans would be. So we can't consider a what if in a vacuum. We're just talking about whether an applicant can create its own hardship, and we've been advised, and we've had the feeling for a number of years that an applicant should not be able to create its own hardship by proposing the hardship and then asking us to absolve them of the hardship. That's my feeling. Members, do you have any questions?
I think it's very similar to the previous matter on South Wilshire Street, and it wasn't even something that I understood. I could understand all the arguments for why it may not have made all that much sense, in the sense that it all fit within the neighborhood. But at the end of the day, it seems kind of clear that we can't. The law says we can't have. An applicant cannot create the hardship, and that's what's happening here. So as a board, we're kind of stuck, I think.
Yeah, I agree. It's not a moral decision. It's a decision if we make it, based on the law has been explained to us. Let me ask.
That's why I feel the same place I did last time. I don't necessarily feel strongly that it's not appropriate to propose what they're doing. It's just that we can't provide it. We don't have the power to grant that variance.
Yeah. Let me ask for the record: is there anybody in attendance, anybody else who hasn't spoken, to speak in favor of or in opposition to the application as filed?
Mr. Chairman, if I can real quick, my name's Amanda Langer. I'm from Jacobs Driscoll Engineering.
Yes.
Just wanted to take a quick chime in. I do appreciate you providing us with the information from the previous denial. In this particular case, as Attorney Vail has pointed out, it's a lot different than the other Worcester Street, I believe it was, 133 Worcester Street.
Yes.
That one is taking basically a 40,000 square foot lot and turning it into 220,000, which made them both extremely non-conforming. I mean, he is taking one lot and making it completely 100% conforming, and the second lot is just barely non-conforming. Just barely. I mean, by a smidge.
Well, I understand what you're saying, although 8,000 feet off of 40 is 20%. So I'm not sure that's a smidge in my book, but
I'm referring more to the frontage, I guess. But
yeah, the frontage may be a smidge, but
we've made numerous attempts to try to reach out to the Norton Historical Society as well to see if we could possibly purchase that key cutout of land. We've not been able to reach anybody in our multiple attempts. So this is sort of like the last ditch effort coming to you guys. So, there has been attempts made to try to get it so that we can completely conform here, but, we haven't been able to really get there.
I appreciate that.
And Chairman, lastly, I know.
Yes.
I may disagree with Attorney Questle, but I do believe that there is some hardship there that you could hang a hat on, and the board could hang a hat on to grant these variances in order to give an opportunity to these clients.
All right,
Mr.
thank
Chairman,
you.
if I can add anything, I mean, I guess at what point do we draw the line in the sand? I mean, the bylaw is what the bylaw states. It clearly states 40,000 feet per lot. What stops if we accept this, what stops the next applicant to come in with a 60,000 foot lot and say, well, you guys allowed it here, why not allow it for me? I mean, we have to, our job as the board is to impose the bylaw, and this is where we stand. It clearly states 40,000 feet. I believe that the applicant, needs to find another avenue to make the lot size bigger. Unfortunately, they can't reach the Northern Historical Society, but they may have to try another avenue. I just don't see how this board can even consider this at this point, this application.
Thank you, Mr. Wozniak. Is there a motion to close the public hearing?
I will make that motion.
Mr. Booley has made a motion to close. Mr. Wren, is there a second?
Yes, I will second to close the public hearing.
Is there any further discussion, members, on the motion to close? Hearing none. Mr. Booley, how do you vote?
Yes.
Mr. Wren, how do you vote?
I vote yes also.
Mr. Noel votes yes to close the public hearing. All right, before us is an application for variance on two grounds. Basically, though, to subdivide a wholly conforming lot into two lots, one of which would be conforming and the second of which would be non-conforming as to frontage and as to lot size, as contained on the plan of record, which has not changed since the last hearing, thankfully. Is there a motion concerning the application?
I'll make a motion to approve the variance for lot 2 on lot size and frontage.
Mr. Wren, is there a second to that affirmatively stated motion?
Yes, I will second that.
Okay. Is there any further discussion on the motion? I will point out that an affirmative vote would grant the variances, and a no vote would deny the variances requested. Mr. Booley, do you vote yes or no?
No.
Mr. Wren?
I also vote no.
And Mr. Noel votes no as well. With regrets to the applicant, appreciate your cooperation and the information, but we feel we cannot grant the relief sought. And thank you for your participation. We will draft an opinion decision in due course and have it posted. Ms. Questle, thank you very much for your assistance tonight. Applicant and counsel, thank you for taking part.
Thank you.
Thanks. It was nice to see you guys.
Okay,
Been a while.
stay safe. Other items on the agenda, I'm going to ask for a motion to close the hearing, to close the meeting at this time. The minutes are not ready for consideration or approval. We have another meeting 1 week from tonight. Is there a motion to adjourn at 8:31?
I will make that motion.
I will second it.
No further discussion. Mr. Booley, how do you vote?
Yes.
Mr. Wren, how do you vote?
Yes.
Before I vote, thank you, Mr. Carmichael, Mr. DiGiuseppe, Mr. Tenori, Mr. Wozniak. Welcome back, if it feels welcome. If it doesn't, tough, you're stuck now for a while. But we're glad to have you back. I vote yes to adjourn. Stay safe. Thank you. See you next week, by the way.
The recording has stopped.